We're all set. Thank you.
All right, great. Well, welcome everyone. Thank you so much for joining us for this special program on Estate Planning 101. My name is Michelle Mayer, and I'm the Director of Development here at the Cancer Wellness Center. For those of you new to the center, I'd like to take a minute to tell you about the important work we do in the community. The center is a nonprofit organization aimed at improving the physical and emotional well-being of those impacted by cancer and their families. Our services include educational programs like the one this afternoon that aim to help you navigate the varied challenges that come with living with a cancer diagnosis, as well as empower you to make the decisions about your health care. Our wellness classes like yoga, meditation, exercise, stress reduction, and more, they provide a holistic approach to healthy living. And we offer support services that include counseling and support groups designated to help cancer patients and their loved ones and those bereaved manage the mental and emotional impact of cancer. If you'd like to learn more about the center and connect to our free programs and services, please feel free to visit our website. It's cancerwellness.org, and the link will be included in the chat. Before we get started, I'd like to acknowledge that this program is open to the public, as decisions around estate planning impacts all of us. So in the audience today, we have participants who utilize the center and donors who support the work that we do. At some point in our lives, we're all faced with questions around estate and legacy we wish to leave behind. And in today's program, you'll learn different options you have and how to take that to the next step. If you're just beginning to think about these questions, or if you have thought about them and are ready to move forward with establishing a testamentary gift, please feel free to reach out to learn how you can include the Cancer Wellness Center in your estate plans. My contact information will be included in the chat as well as in our follow-up email. And lastly, just a few housekeeping items. As this program is being recorded, you already saw that the audio was disabled. So if you have any questions during the presentation, please type them into the chat or save them for the Q&A at the end. And our presenter will answer questions after his presentation. After the program, you'll receive an evaluation, and we ask you to take a few minutes to provide your feedback. We really appreciate it, and it really helps us as we plan more programs. So without further ado, I'd like to welcome our presenter, elder law attorney Matthew Margolis. Matt has been practicing in this area of estate planning and elder law since March 2011. He brings years of experience, and we're honored to have him today. To learn more about Matt and connect, you can visit his website. That link will also be included in the chat. So welcome, Matt, and thank you all for being here. And Matt, you're muted. Sorry.
You know, I've only been doing Zoom for the last 3 years now, and I still sometimes don't look down there to see if I'm muted or not. So thank you again, Michelle and Savita, for inviting me to speak today. You know, way back when we actually used to do these in person, I spoke in person at the Cancer Wellness Center. I want to say it was a couple of years before the pandemic, at least. And I think we did one of these in the past couple of years as well. So thanks for having me back. This is a topic that we speak about quite often. It's a big part of our practice, and you know, we're very passionate, my partner and I, just about educating the public on their estate planning options. You know, we feel that a lot of people don't go down the path of estate planning because they really don't understand the differences between wills and trusts and what powers of attorneys documents are. You know, it's overwhelming. And sometimes people just don't want to think about it because, you know, when we talk about estate planning, it's like people don't buy life insurance because we know why we're buying life insurance, right? Because we're admitting that at some point we're going to pass away. And these are things that we don't like to talk about. We don't like to admit, even though at the end of the day, you know, we all have an expiration date, unfortunately. So, you know, we might as well plan for it. Okay, better that our plans take over than whatever the plans that the state of Illinois has in place for us. Okay. I think Michelle did a nice job. You know, you don't need too much more background on me. As she mentioned, I've been doing this since 2011. My partner, Lauren Weldon, and I have what I sort of call a boutique elder law and estate planning practice in downtown Park Ridge. We've had it for the last 8 years. And this is all we do. All we do is estate planning and elder law, right? We don't do real estate transactions, divorce work, personal injury work. We stay in our lane. We live and breathe wills, trusts, and helping the aging population with that last chapter of life, whether it's sort of dealing with bringing in caregivers into their homes and applying for Medicaid and all those things. So that's sort of the makeup of our firm and sort of how we help people. But today's topic is estate planning 101. Again, something we talk about on a weekly basis, something I probably almost talk about on a daily basis. I'm surprised I don't have dreams about it, to be honest with you. So, and what I'll tell everybody that's tuning in today, and I'm very honest in saying this, the information that you're going to get and the way that I present this is identical to if you were to call my office and say, Matt, my husband and I, or my wife and I, or just me, I'm interested in doing some estate planning. And so the information I'm going to present and the way I'm going to present it is identical to that first meeting I would have with a client who's interested in doing some estate planning, because that first meeting is all educational. Again, people need to understand what their options are before they can do anything, before they should do anything. Okay. So as Michelle mentioned, I think she mentioned this, but I'll repeat it. Obviously, everybody's audio is disabled. If you have a question, please type it in the chat box. The presentation goes till 1. My goal is going to be to try to at least cut my talking by 12:50, so that I've got about 10 minutes at the end to answer some questions for those of you that have questions. All right, here we go. So when we look at estate planning, we really are talking about two main paths, all right? And estate planning is very general, and there's way more to it than we're going to discuss today, but we are really going to discuss the basics. We're going to discuss what is applicable to, honestly, about 99% of people. And so we're going to be talking about a will and a trust, because these are really the two main paths that people go down. And the type of trust that we're going to talk about, and I'll repeat this, is a revocable living trust. Because again, there are different types of trusts out there. So I want to make sure that you're understanding the type of trust we're talking about. So let's just use me as an example, right? It's easier to talk in the first person, easier for me to pick on myself than anybody else. And so, I've got some stuff. Like many of you, we've gone through life and we've accumulated various assets. And honestly, I don't care how much or how little you have. We all have something, and for the most part, and I've been doing this long enough to be able to say this, I hate to say that actually, but I've met very few people, and I can count on one hand, and it doesn't even fill up a whole hand, very few people that don't really care about what happens to their stuff. And so most of us, right, the majority of us that have some stuff, whether it's a lot or a little, care about who it goes to. And we care about how it goes to them, depending on who they are. Are they younger? Are they older? Are they immature? Are they responsible? Are they disabled? Do they have a drug problem? Is their marriage on the rocks? Is there reasons why we basically need to leave them money in a protected way so that we can protect them against themselves or somebody else? Okay. So, planning is not a one size fits all type of deal. Everybody's got their own family dynamics, their own situation, and we have to figure out the right fit for them. All right, I digress. So I've got some stuff, right? And I'm going through life and I've got all this stuff. And the question becomes, what happens to it when I die? Well, for those of us that are married, a lot of us sort of have a very easy way of this being dealt with, at least until the first spouse dies. Right? So a lot of married couples kind of can get off very easily with doing no planning. Now, I'm not suggesting that you married couples out there don't do any planning. I'm just saying that a lot of married couples can get away with it. Why? Well, let's talk about this, right? Let's look at my wife and I before we did any planning. We had checking accounts and savings accounts and a brokerage account and a condo in the city. Well, all of those assets were owned jointly. The bank accounts were in both of our names, right? The condo was in both of our names. And the assets that were not in both of our names, the life insurance policies and the retirement accounts, we named each other as beneficiaries. And so even if I had a will that named Savina as my primary beneficiary, right? Savina gets everything when I pass away. The reality is, in that case, Savina gets nothing. And my wife would get everything, because the joint ownership on those accounts and the beneficiary designations supersede the language in my will. Okay? So not only does that stuff supersede the language in my will, but just so you all know, even if I didn't have a will, there would be no issue. I would have no estate issues. Nothing would go through probate. And we'll talk about what probate is in a second. So a lot of married couples kind of avoid having problems, avoid not doing any planning by virtue of how they own their assets. Now, again, you'll notice I'm not saying every married couple, because I meet a lot of married couples that don't own everything jointly. Some of you that are listening here may be married and not own everything jointly, and not just the assets that can't be owned jointly, like the life insurance policies and the retirement accounts. Some of you might have a brokerage account in your name only, or a savings account in your name only, especially if it's maybe a second or third marriage. So let's talk about what happens. And it's just easier for me to speak this way. So even though I know that I'll pass away first, let's use the example that my wife passed away before me. Now all the assets are in my name only. Now I have a real need to plan. Because at this point, if something happens to me, while the retirement accounts and the life insurance policies should have beneficiaries on them, and I say should, I'll tell you, we meet people where by the time we meet them, they're a widow or widower, and we're going through and we're talking about beneficiaries on their accounts, and guess what? Their spouse who predeceased them was the only beneficiary on their life insurance policy or their IRA. They never had their 5 adult children named as contingent beneficiaries. That's unacceptable, guys, right? So go check your beneficiary designations, all right? If you take away nothing else from today, and I really hope you do, go check your beneficiary designations and make sure that it's not just a primary beneficiary you have on there, but you've got contingent beneficiaries, okay? So if I'm a single individual or a widowed man, yes, I've got beneficiaries on my retirement accounts and my life insurance policies, but what happens with my house that's in my name only? What happens with my bank accounts? What happens with my accounts at Wells Fargo? Where do all those accounts go when I die? Well, I'm going to tell you what happens in a lot of cases. All those assets go through this process called probate. All right, and if I saw everybody's faces, I'd ask you to raise your hands. I could probably change my view and see everybody, and I'll do it. And I could say, how many of you have ever dealt with probate or are familiar with probate? And probate is the court process, okay? Probate's a court process where somebody's estate has to be dealt with because it was left in a certain way. In Illinois, if you have an estate that's over $100,000, if you have assets, let me make this easy to understand. We're all about easy. If you have assets in your name only, okay, not assets that have beneficiaries on them, so not life insurance policies, not retirement accounts. If you have assets in your name only that are not owned jointly with somebody else, that exceed $100,000, the total of them exceed $100,000 at the time you die, those assets will go through probate. They will go through this court process. Okay, now probate's not the end of the world. It's not ideal, okay, at least in my opinion. Okay, some of you might care what my opinion is, some of you might not, that's okay. But in my opinion, probate's not ideal, but it's not the end of the world, okay? Here's why, right? Probate, I'm gonna presume most people tuning in today probably live in Cook or Lake County, and even if you live in another county, sort of, friendly to those two, this will probably be pretty true, but most of the work we do is in Cook and Lake County. The average probate case that we take on probably takes about 18 months from start to finish. Okay, so from the time we file the case in court to the time we're done, I'd say it's probably an average of 18 months. Okay, now it's not like you're going to court all the time, and in most cases, you're not even, if you're dealing with a probate estate for a loved one that passed away, you're not even physically going to court. Nowadays, courts handled very much like this talk today via Zoom. And if anybody's going to court, it's the lawyer, it's not you. Either way, it's about an 18-month process. Okay, even for a fairly simple estate. Simple estate meaning, a handful to 10, various bank accounts or investment accounts and maybe a piece of real estate. Once you start getting more complicated, there's 2 or 3 pieces of real estate, there's 25 different bank and investment accounts, it's a $10 million estate, that can take longer. But, most cases that we handle are more straightforward. And so I'd say they're about 18 months, and I'd say the average cost is probably somewhere between $4,500 and $8,000 in attorney's fees and court costs. Again, I will say not the end of the world. I would also say fees that most people would prefer to avoid. Okay. And then I always throw in this little tidbit, of course, there's a little bit of aggravation with probate, right? And it's not aggravation for me. I'm dead. Who's dealing with it? Most cases, my kids or whoever I'm leaving behind, right? Probate's a mess that we leave for somebody else to clean up. Maybe it's our way of getting back at our kids for leaving those messes on the floor that we had to clean up for all those years. But that's just me talking because I'm living through that right now. And of course I would never do that to my kids. But that's sort of how probate works. Okay, again, not the end of the world, but we can avoid it. Okay, and I would say that the name of the game for most people that we meet with these days is avoiding probate. Okay, how do we avoid probate? This is where, if you guys could talk, I'd let somebody try to answer my question, but I'm just going to give you the answer anyway. In most cases, we use a trust to avoid probate. Okay, this revocable living trust that I talked about a few minutes ago. Now, when I bring up the idea of a trust, there's a couple things, right? And I'm going to go back to the beginning, but I'll talk about the trust for a second. When I bring up the idea of a trust, I feel like a lot of people have this concept. If they know nothing about trusts, if they don't have any family members that have one, if their friends have one, that probably doesn't mean a whole lot. But if they don't have any familiarity with family members that are close that have trusts, I think a lot of people have this idea that trusts are for wealthy people. Trusts are for the Pritzkers. They're for the Ricketts, right? Because maybe you went to high school with a trust fund kid, right? Everybody here has seen enough movies, watched enough TV shows. We all know about Paris Hilton. And so we associate trusts with wealth. And it's true. Trusts do really help people with a lot of money because we can use trusts and various kinds of trusts to help reduce our estate tax liability if we have lots and lots of money. Great. However, I can tell you that 99% of people don't put trust together because of the amount of money they have. Okay. In Illinois, you don't have a taxable estate where you have to start using a trust to help avoid estate taxes unless you have more than $4 million. Now, again, depending on the neighborhood you live in and your circle of friends, maybe you all have tons and tons of money and that's like everybody you know. But I will tell you right now, I've been doing this for 12 years. I can tell you that 95% of my clients that we put a trust together for have less than $4 million. Okay? 95% of the people I put a trust together for have less than $4 million. So we're not putting trust together just because we have tons of money. We're doing it to avoid probate. That's what we're using a trust for. Okay? And then to go back and talk about the will for a second, a lot of people think that a will is all they need. Because like, oh, my grandma had a will. It was simple. She died, her will said everything went to my mom and her 3 siblings and everything got split up and it was good. Times are different, people. I can't tell you what happened 30 years ago when grandma died, but I can tell you what happens now when people pass away. I wasn't practicing law 30 years ago. I can't speak to how probate worked and what the rules were and how all of that went down. But I can tell you now, again, We're not using trust because we have tons and tons of money. We're using trust just to make things easy for the people we're leaving behind. That's what it is about. So how does a trust work? So I'll use the concept of creating a trust by myself, and I'll use the concept of creating a trust with a spouse. And then I'll talk very, very briefly about the idea of using trust when we do have more than $4 million and why we would do that. So if I'm creating a trust by myself, I'm a single individual creating it, I create the Matt Margolis Trust. Okay, I can call it anything I want. I can call it the Illinois Trust, the MRM Trust, the I Love Cookies Trust. I've had some clients create some very weird trust names over the years. The Ngodwe Trust. You call it anything you want. I just tell my clients, just be ready that when you go to the bank and you retitle your account, you're gonna have to be comfortable telling the bank that you want to, title your account to the Cookie Trust. So I've got the Matt Margolis Trust. My trust operates off my social security number. Okay, so my taxes don't change. I file my taxes just like I do every other year. I'm the trustee of my trust. I'll talk about what that means in a second. With a revocable trust, I can make changes to it over time. Now, if I have a will in place, to get back to the will, I might go back and forth a little bit, and I apologize. If I have a will in place, I can make changes to a will as well. I can change a will and I can change my revocable trust as often as I want, as long as I have capacity, right? If I lose capacity, no more changes, all right? Now, to avoid probate, right? Because most people, like I said, 95% of the people we meet with, that's a pretty good guess. I haven't run the numbers yet. I probably never will, but 95% is a pretty good guess. 95% of the people we create the trust for are doing so to avoid probate. But it's not good enough for my clients just to come in the office, us put a trust together, have them walk out, and they're going to avoid probate. Not so fast. We actually have to retitle the assets to the trust. And this is where people can sometimes fall short, right? So what I'm going to say, what a competent attorney should do is they should help retitle any real estate, okay? So we're going to always help our clients retitle real estate. We're going to take your house in Deerfield and file a deed with Lake County and transfer ownership from Savina to the trust, right? And now Savina's trust owns her house, not Savina individually. And if Savina owns a house in Wisconsin as well, we're going to work with an attorney in Wisconsin, and that attorney in Wisconsin is going to take Savina's beautiful lake house and transfer it into her trust also. And we can do that. We can transfer a property outside the state of Illinois into a trust that we created inside the state of Illinois. Does not matter, okay? Don't ask me about international properties, okay? That's where you got to talk to an international attorney. So we'll take care of the real estate, all right? So the real estate gets retitled to the trust, but this is where there's homework for the clients. This is where there's homework for the person creating the trust. When somebody puts a trust together, again, it's great. And the attorney, and again, we will do this, and every attorney that does this type of work should be retitling their real estate. But what also needs to be retitled to the trust are the checking accounts, the savings accounts, the brokerage accounts. Okay, all those non-retirement and non-life insurance assets should be retitled to the trust. Okay, and attorneys should be giving direction to their clients about this. I always joke around with my clients, I'm not going to hold your hand and walk into Bank of America and retitle that account with you. I mean, I will if you pay me extra money, sure, I'm happy to, but you don't need to. It's easy. Banks do this all the time. Again, we're living in a world where trusts are very common. They weren't 30 years ago. So we tell our clients, and an attorney should be telling their client what to do with all their accounts. But we have to retitle them to the trust. And when it comes to the retirement accounts, the IRAs and the 401ks and the 403bs and the 457bs, depending on where you worked and what sector you were in, and the life insurance policies, those, we just need to make sure we've got good beneficiaries. And in some cases, we may name the trust as a beneficiary. It just depends. Okay, again, it really depends on a person's situation. You know, do they have minor children? Do their beneficiaries have special needs? there's certain reasons why we might name a trust versus naming individuals as beneficiaries on the life insurance policies and the retirement accounts. Again, these are conversations that people should be having with their estate planning attorney. Okay, there should be guidance related to these things. These are not decisions. These are not decisions that a client should be left to make on their own. That's how we avoid probate. Okay, we avoid probate not just by creating the trust, but by properly funding the trust. And I will tell you that this slips through the cracks a lot. How do I know that? Because plenty of clients come to me who did planning with an attorney 15 years ago, 10 years ago, 20 years ago, and they put a trust together. And I look, and they're typically coming to me to review the trust, and they want to make changes, and time has passed, and the attorney's retired or passed away, or they just lost touch with him or her. And not only am I reviewing their documents, but I'm also having them fill out a personal information form while I look at all their assets, and I ask how their assets are titled. And I have columns that say, is it titled in your name? Is it titled jointly with your spouse? Or is it titled in the name of your trust if you have one? And inevitably, that trust column is blank. Very rarely do clients come to me that have a trust in place with assets that are titled in the name of the trust. And when I say very rarely, I'm going to say probably no more than a third of the time, which to me is rare. Okay. These are things that have to happen. Because you might as well just put a will together. If you're not going to retitle your assets, just put a will together. Don't put a trust together. Because you're going to go through probate anyway. And I'll explain that. So as the trustee of my trust, now that all my assets are in the name of my trust, my checking account, my savings account, my brokerage account, my real estate, as the trustee, I can manage all that stuff just like I did before I had a trust in place. My life doesn't change at all. Zero. Okay? I go about my business as I always did. Literally no changes. Now, if I have a joint trust, then my wife and I are creating the trust together. We are both the trust makers, okay? We can both make changes to it as long as we have capacity. We are both the trustees, meaning we both have access to everything that's in the trust. Think of it like being joint on something, just like we were before we had the trust, and we were joint on all the bank accounts. But whether I have a trust by myself or a joint trust with my spouse, we need to have successor trustees, because at some point, we know we will both pass away. And before that, one or both of us might be incapacitated. So who's going to step in as a trustee and manage the assets in the trust? What if I pass away and my wife is alive but has dementia, and dementia to the point where she can't make her own decisions? Then we need that successor trustee to step in and manage the assets in the trust for her benefit. Similarly, we need that successor trustee to step in and manage the assets when we both pass away. We can name as many successor trustees as we want. Now, of course, this makes me realize I forgot to talk about something with the will, right? When we have a will in place, you guys are probably familiar with the term executor, right? At least some of you probably heard this term before. I always love when adult children walk in my office and say, they're like beating their chest saying, I am my mom's executor. Great. Until mom's dead, you're not anything except her son. When we name executors of a will, it's very similar to the idea of a trustee of a trust, right? Who's going to be in charge? Who's going to manage the estate? The only difference is with the executor of a will, an executor does not kick in until somebody dies, because a will does not kick in until somebody dies. With a trust, though, I hope it's clear, a trust is a living, breathing document from the day we sign it, right? It can own assets. My wife and I could be incapacitated, and the trustee could step in during our lifetime and manage things for us. Whether we have trustees of a trust or executors of a will, we can name as many people as we want as successor trustees or executors. We can also name co. So I can name my brother and my sister-in-law as co-trustees. They can act together. If we're going to name co-trustees or co-executors, I really hope they get along. Okay, if we've got two children that don't get along well, hoping that they get along when we die is probably a pretty bad guess. Okay. If anything, they'll probably get along worse, just from what we've seen. Sorry. We sort of talked about how a trust works with a single person, with a married couple, and then with a joint trust. The situation where we would use two trusts for a married couple. So in some cases, we would use two trusts for a married couple versus a joint trust. And I'll be very brief. We do this in situations where it's maybe a second or third marriage and the couple does not maintain joint assets and they keep everything separate. Then of course, we're not going to put a joint trust together. And then similarly, in situations where a couple has an estate that's over $4 million, which is the Illinois estate tax limit, which I mentioned earlier. If we have an estate tax, if we have an estate that's over $4 million, we'll use two trusts because we can use the two trusts to help avoid estate tax liability. Even though it won't take me long, I don't want to go down that path of talking about how that works. If it applies to you and you want to do any planning, I'm happy to talk to you offline or follow up with another estate planning attorney, of course. But I want to make sure that we cover everything. Just letting you know that if that's the case, two trusts does make sense because we can use two trusts to hedge our estate tax liability for a married couple. So when my wife and I pass away, all right, whether if I have a single trust when I pass away, or when the second of my wife and I pass away and we have a joint trust, or frankly, when the second of my wife and I pass away and we have two trusts, everything goes to our beneficiaries, right? And first, before that, there's an administrative period, right? First, taxes are paid, just even if it's not estate taxes, just regular income taxes are paid. There's going to be some outstanding bills. Real estate has to get sold. I always tell clients who lose a loved one, relax. You don't need to turn around and write checks to your siblings tomorrow to settle mom's estate. This is a process. They might have to wait 8 months, honestly. So of course, what happens is mom dies and brother is knocking on the door saying he needs the money. And of course, my response is always, what if mom didn't die for 2 years? I think he'd be okay. He probably would have figured it out. So once it's time to distribute the assets, we distribute them to the beneficiaries, right? And we can leave money, obviously, to children or grandchildren or whoever you want. Leave it to the Cancer Wellness Center, charitable bequests. Sometimes there are specific bequests where we leave specific dollar amounts. I'd say what's more popular, what we see a lot more done these days, depending on the size of the estate, is typically we'll have clients leave everything in as a percentage, right? Some clients will say, I want to leave $50,000 to so-and-so. And I'm like, listen, you've got a $500,000 estate. You want to leave $50,000 to your niece and then $50,000 to your nephew, and then the rest goes to your 2 kids. What if you have long-term care needs and you end up spending $800,000 in a nursing home over the last 6 years of your life? Based on that, the first $100,000 will go to your niece and nephew, and then the remainder will go to your 2 kids. So I typically tell clients, okay, you want to leave them $50,000. You have about that. You have a $1 million estate or whatever. I don't know. I just switched up the numbers, but let's say you want to leave them $50,000 and you have $1 million estate. Give them each 5% of the estate. That way, whether you have $1 million or $100,000, they're going to get 5%. We don't know how much money we're going to have when we die. Now, again, if we have millions of dollars, being able to leave things like that is a little bit different. Okay, again, this is about conversations, having conversations with the attorney that you're working with, whoever that is, to make sure it shouldn't just be, and I mean this very respectfully when I work with clients, I tell my clients, I'm going to challenge you respectfully. You're paying me for my advice. If I just said yes to everything you wanted to do, you might set things up in a way that may not actually accomplish what you want to be done. Let's make sure that we accomplish what you want, but we do it in a way where if the goal is that your kids get the most money and that your niece and nephew get a percentage or, some amount, but not a ton, then let's make sure that happens. And we do it in a smart way. Because a lot of people don't really think about the idea that, oh my gosh, you're right, I could spend a lot of money later in life without really realizing it. And then we also have to think about the idea that somebody may not survive us, right? And we don't want to think about those things, right? What if my son doesn't survive my wife and I? Where would his share go? Would it go to his kids? Does a beneficiary share go to their spouse? Most cases, it would go sort of down the bloodline, right? That's more common. It's not what it has to be, obviously. Again, there's a lot of decisions that have to be made. Also, when we're leaving money to beneficiaries, we can leave it to them outright, meaning if there's $1 million at the end of the day, after all taxes and expenses are paid, I've got 2 kids, the trustee writes a check to each kid for $500,000, they can do whatever they want. Or we say, you know what, and here's what my trust says. My trust says that if my wife and I pass away and our kids are under the age of 30, 2 little trusts are created that spring out of our trust. These aren't separate documents that we've drafted. There's a trust that springs out for our son and a little trust that springs out for our daughter. Each trust will be funded with half the estate, and my brother, the trustee, would manage the money for their benefit until they turn 30. And it's there, he can use it for them, just like we would have used it for them if we were alive. And then when they turn 30, he can turn it over to them. Okay, and we do that because we don't know if they're going to be how responsible or irresponsible they're going to be. We go out on a limb and say, listen, hopefully by 30, they're responsible enough to manage the money. If they're not that responsible by 30, oh well, so be it. Probably won't be that much more responsible by 35. So every time we put a trust together, we always create a will. Okay, a will always goes with a trust. We call it a pour over will, like a pour over coffee. Okay, if any of you are that fancy. So a pour over will. And the pour over will is really a safety net. Safety net for those situations where people don't properly fund their trust and something slips through the cracks. Right? Let's say I put the trust together, I fund it with the real estate, I get most of my bank accounts in there, but I forget there's some bank account that I forget about. Or my wife and I are lucky enough to purchase some lake house 20 years down the road after we put the trust in place, and we forget to retitle the property in the trust. And when we pass away, that property is in the survivor's name. That property would go through probate, or that bank account would go through probate. The pour over will is a really simple will that basically says, hey, judge, if you're reading this, 2 things happened. Number 1, I died. Number 2, this asset slipped through the cracks. It's in my name, but I have a trust in place. So at the end of this probate process, because it will still go through the whole probate process. Okay, there's no expedited probate process because I've got a pour over will. It goes through the whole probate process, and at the end of it, that asset pours over into my trust, and then the trust distributes it according to its terms. Okay, again, a safety net. Not ideal. I tell every client, we're going to put this pour over will together because that's what we do, but I hope you never use it. We're going to talk about it. You're going to name executors. For those that have minor children, this is also where we name guardians. Okay, we name guardians for minor children in a pour over will, right? Who's going to take care of our kids who are under the age of 18, if they're under the age of 18 when we pass away? So we hope this pour over will never comes into play for a couple reasons, obviously. So every time we create a trust, a will always accompanies it. But every time we create a will, we don't necessarily put a trust together, right? I'm seeing some, for those heads I can see, I see some nodding. So I'm hoping that the rest of you agree as well. Guys, that's sort of how a trust works. That's sort of how a will works. It's not rocket science, right? This, I hope this didn't seem like rocket science. These are, I know it's a lot when we've never done it before, when we've never kind of gone down this planning path. It can be intimidating. These are conversations we don't like to have, but we really try to make it, and I hope most other attorneys try to make it as simple as they can. Anytime we do any kind of planning where we're putting together wills and trusts, there's other documents that we put together as well, and most other attorneys would also. Okay, and so these documents are healthcare power of attorney documents, property powers of attorney, HIPAAs, and living wills. All right, so in Illinois, we have 2 types of power of attorney documents, healthcare and property. The healthcare power of attorney is where is a legal document where we get to name somebody to make medical decisions for us. in the event that we cannot make our own. I can name as many people as I want on my healthcare power of attorney, but I am naming them one at a time in a particular order. I cannot name co-agents. Some states allow that. I think our neighbors next door in Indiana do. For good reason, we don't. The last thing I'd want is two people be fighting over what medical decision to make for me in an emergency situation, especially in a case where they both knew what my decision would be had I been able to make it on my own. Okay. The one thing I'll say here, because I don't need to go into a whole lot more with the healthcare power of attorney, is it's so important to name the right person. You know, I have so many clients where when it comes to naming their powers of attorney, they're always, and they've got adult children, because most people will name their spouse first if they're married. Okay. Makes sense, obviously. And then most of the time, if they've got 3 kids, they're naming their 3 kids oldest to youngest. And of course, my comment is always, I just hope that's the right order, because I hope it's not just, you're naming your oldest first because you don't want him or her to feel slighted that you name the youngest one first when the youngest one would actually be the best person to name. Being a medical power of attorney is difficult, especially, listen, I've been doing this for 12 years. I can tell you that 98% of the people I meet with do not want their lives artificially prolonged. Right? It's like me. Do what you can to keep me comfortable, but I don't want extreme measures taken. If this is the end, let it be. I don't want machines. I don't want to be the proverbial vegetable. If I'm going to be a burden and you're just going to keep me alive to keep me alive, it's not what I want. That's not good for anybody. But I've never had to make that decision for a loved one, and I can only imagine how hard it would be if I had to. So you've got to make sure that the person, if that's how you feel, you got to make sure that the person you're going to name is okay making that decision for you, and you got to feel confident that they would. I won't go into more detail than that. You can take it from there, but you really have to make sure that somebody's comfortable making your decision for you, because at the end of the day, that's what it is. They're making your decision for you. They're not making their decision. The property power of attorney. This is the financial power of attorney, right? Who can make all non-medical decisions for me. Same thing as healthcare. I can name as many people as I want. It's one at a time in a specific order. The only difference here is that the property power of attorney is not going to make decisions over anything that's in the trust, because anything that the trust owns, that'll be the trustee, right? That successor trustee will step in and manage what's in the trust. So things that the property power of attorney would deal with, because as far as things that are not in the trust, would be like retirement accounts, because IRAs and 401ks are not in the trust. Life insurance policies are not in the trust. We deal with those, remember, with beneficiary designations. Filing my tax returns, that's my property power of attorney. Signing a contract. Maybe I'm hiring a caregiver needs to be hired to take care of me. I need to move into a nursing home. There's issues that arise with Social Security or Medicare. These are all issues that my property power of attorney would handle. In most cases, the people that we name as our property power of attorney tends to match up with the people that we name as trustees of our trust and executors of our will. We tend to name the same order of people for those 3 categories, because we're kind of thinking of who's good at more of the administrative, legal, financial tasks. And again, inevitably clients are always like, oh, my son is an attorney, or my daughter's a CPA, or my daughter's a financial advisor. They'd be perfect at this role. Maybe, but I'm like, you are none of those, and you've been able to manage your life for 75 years. So why do you think that the person that does it has to be one of those? I'm like, it just has to be somebody that's good at taking care of business. Is that like an Elvis quote or Elvis song? Somebody that's good at getting stuff done. Your son, the lawyer, if he's filing his taxes late and he pays his bills late, probably not a good power of attorney or trustee. Just because he does that for a living doesn't mean that his home life is the same. So just, again, things to think about, right? That stay-at-home mom or stay-at-home dad might be way better for this role than the spouse that's working 65, 70 hours a week. Because do they have extra time to also run your life? No way. They can probably barely run theirs. Again, think these things through. The HIPAA. So the HIPAA is the healthcare authorization. Who can have access to my medical records? This is not decision-making authority. This is strictly access to information. You've probably been to the doctor or the hospital at some point in your life and had to sign HIPAA authority. Sometimes it's just giving one doctor the ability to request records from another doctor. On your HIPAA, so the HIPAAs that we draft, at least, we have clients name people that can have access to their medical information. There's no specific order, okay? And again, it's not granting them decision-making authority, strictly access to information. For example, my HIPAA has my wife, my parents, my siblings, my in-laws. Okay. There are 8 people on there. Any one of them at any point in time can go to my doctor and ask for copies of my medical records. I doubt that they would ever do that, but they could. And I have to be comfortable with the idea that they could. The reason I like the HIPAA is not because of that. It's because if there's an emergency and I get rushed to the hospital, any one of them can call the hospital and find out what's going on and get information. And they wouldn't all bombard my wife. Lastly is the living will. The living will is the do not keep me alive unnecessarily document. This is really more direction to your healthcare power of attorney that you don't want your life artificially prolonged. This is not the same force and effect of a POLST. If any of you are familiar with a POLST, which is the DNR, POLST stands for Practitioner's Order for Life-Sustaining Treatment. It's sort of the beefed up DNR that we've got in Illinois over the last 10 years. All right, with a POLST, we can decide whether we want to be resuscitated or not. We can decide what kind of what level of treatment we want if we have a pretty severe medical situation where we can't make our own decisions. We can decide how we feel about artificial nutrition. Okay, the POLST is a doctor's order. So I always give the example: the paramedics come in my house, I have no pulse, I'm not breathing. I have a pulse next to me. Whatever the pulse says, they're going to follow. If it says don't resuscitate me, they're not. Same situation, the paramedics come in, no pulse, I'm not breathing, and I have a living will next to me. They're going to throw that document off of me, and they're going to put the paddles on me. They're going to give me CPR. They're going to do everything they can to keep me alive. Okay, that living will is just more direction to my healthcare power of attorney that I do not want my life artificially prolonged. So for those of you that have very, very strong wishes about end-of-life treatment, I recommend looking at the idea of a POLST. But I can tell you that a lot of doctors, because it has to be signed by a medical professional, and a lot of doctors and medical professionals that have to sign it are unwilling to sign it unless somebody is pretty advanced in age or they have a terminal illness. Just letting you know that. I've got plenty of clients of mine in their 60s and 70s and even early 80s, and their doctors will not sign it because most people don't think about it. If I have a heart attack and I have no pulse and I'm not breathing, I would want to be resuscitated. And most people would, unless they were of an advanced age. So, all right. Well, that's all I got. I joke around, I give this talk all the time, and I wish I had like a smoother ending. I just don't. But I want to jump into the questions. I thank everybody for listening. But because we've got about 7 minutes, and I can go a couple minutes over, but it depends on Sabina's time. So Sabina, if it's okay with you, I'm just gonna start going through the questions.
Yeah, if you don't mind just not reading people's first names, just because.
Oh yeah, no, I won't.
Recording. Thank you so much.
Of course. All right. How do you add your children's names on your deed to avoid probate? So while I don't love that as an option, as from just like how do you do it standpoint, you have to do it through a quitclaim deed. So I would recommend contacting an attorney, whether it's an estate planning attorney or a real estate attorney, and they can help you out with it. It's probably not just something the average person would be able to figure out how to do on their own, but it's not a complicated process. Again, I don't recommend that only because if you add your kids' names on the property, it does avoid probate. But if somebody sues your kids or your kids get a divorce, guess what? That property is just as much theirs as it is yours, and their legal issues are your legal issues. So it's an inexpensive way to avoid probate, but it could be a very costly mistake if something bad happens. So somebody said, I still struggle to understand the concept of a trust. Years ago, all we had were wills. What is the difference in a nutshell? I think I said that earlier, basically avoiding probate. If I want to divide all my assets into percentages, i.e. 10% to 10 different people or causes, do I have to do that with a trust? Not necessarily. With a lot of IRAs and life insurance policies, you can divide it up 10%, by percentages. I don't know about bank accounts and brokerage accounts. You might be able to do that at Chase and Bank of America and like the Wells Fargos and UBSs and Morgan Stanleys of the world. You just have to talk to your financial institution and see if that's something they can do. Again, things to consider, and obviously, you're talking to a planner, and this is what I do, so you're going to get my 2 cents when you ask a question like that. But when you just think about it this way, though, when you do all those percentages, again, I always think about what if one of those people doesn't survive you? If you wanted to go to their kids and you set up the percentages that way, it may not trickle down the path you'd want it to. If you're okay with it just kind of going to the other 9 people, then that might be totally fine. Okay. Just something to consider when you're doing things like that, when you're setting up beneficiaries on accounts. Is it the same for IRAs as for other retirement accounts like 401ks and 403bs? Yeah, IRAs, 401ks, 403bs, 457bs, all those retirement accounts, you kind of treat the same when naming beneficiaries, correct? What is the estate tax liability if every asset's in the trust? If we have an estate under $4 million, whether it's in a trust or not, there's no estate taxes. If we have an estate that's over $4 million, then the short answer is that we just need to plan the right way. So it's hard for me to say what's the estate tax liability if every asset's in the trust. I would just, the better answer is if an estate is over $4 million, there will be estate taxes unless you plan with trusts appropriately. And if you have an estate that's under $4 million, with or without a trust, there will be no estate tax liability. You might have probate if you don't use a trust, but you will definitely not have any estate taxes. I worry that either my husband or I will need to be in a nursing home. It's so expensive. How can I protect my real estate and retirement funds so we don't lose our assets? So we assist clients with asset protection work in this respect. We do a lot of work where we help people that are worried about spending a lot of money on long-term care in nursing homes and helping them protect assets where they would end up applying for Medicaid. Retirement funds are very hard to protect. I will be very upfront. You cannot, to put retirement funds in a trust, and we use a certain type of trust to protect assets from Medicaid, not the revocable trust that we talked about before. So big disclaimer, the revocable trust we talked about today, great at avoiding probate, does not protect your assets from Medicaid if a loved one ends up in a nursing home. Those assets in the trust are just as on the table as if they were in your name individually, just so everybody knows that. But retirement accounts are very hard to protect from a Medicaid standpoint. It doesn't mean that there isn't anything you can do. But if that's something you're interested in, that's a longer answer, and that's probably something that it's something we'd be happy to set up a consultation to discuss. It's the best way I can answer that question. Do cars go into a trust? Typically, no. You can. If you have a car that's paid off, you can go to the DMV and bring a copy of your title and a copy of your trust and retitle it. We typically don't tell clients to. It's an easy asset to deal with when somebody passes away. So I tell clients all the time, either you go to the DMV and deal with the nightmare that the DMV is to retitle it, or that's the one issue that you leave for your son or daughter, and they can go to the DMV and they can retitle it to their name. I'm okay with leaving that to the kids. What about specific things? What my mom used to refer to as the cups and saucers part of a will. If you have a trust, how are those items you want specified to who gets what handled? Thank you for doing this today. But you're very welcome. If you have a trust, we still deal with personal property. So we actually have clients sign something called an assignment of personal property. It's basically like a blanket statement. It's a one-page document that says, I hereby assign all those things that really have no title to my trust, right? My cups and saucers and my car, which does have title, but basically I hereby assign all my personal property to the trust. And then in the trust, we actually specify, and we can say, I want my cups and saucers to go to Lori. I want my, I don't know, fancy forks and china that nobody cares about anymore to go to Joanne. So we do it that way. And then of course, a lot of clients just make a blanket statement and say all my stuff goes to my kids and they can sell it or donate it or do whatever they want. Is there a threshold estate value for setting up a trust? What are the considerations? There's really not, honestly. I've put trusts together for clients that have had 80 to 180, $75 to $100,000. I would say though, most clients we do planning for, if they've got like the client that had like $75 to $100,000, they also had a condo or a house. So I would say most people we put a trust together for probably have a piece of real estate, and then they might have significant, cash assets or not significant cash assets, but having a piece of real estate is typically enough reason to put a trust together. Now, if they don't have a real estate, I'm not going to say that it doesn't make sense to use a trust, but that's where we might say, okay, if you've got like $50,000 in a checking account, we probably don't need a trust. So it really depends. I would say that while our default is that trust typically makes sense for most people, there are definitely enough situations that we see where a trust does not make sense. And I'm very honest with clients about when I think a trust makes sense and when it does not. And typically we'll just give options and say, listen, you can go this direction and you'll be fine, or you can go in this direction and you'll be fine. It's really up to you. All right, some nice comments. I appreciate that. What are the drawbacks versus benefits of doing a living trust via online process like LegalZoom? You don't have enough time for me to comment on this, but I'll give you my short answer. Here's the thing, the problem with the online document programs are that you don't know, those programs are not intuitive to get you to think about certain things beyond the surface level. Right? So some of the things that we're going to ask our clients when we talk about, does this person have any special needs? Is this person good with money? Does this person have, is their marriage on the rocks? Does this person have any, but not even that, sometimes it's just that I've seen clients where they didn't sign the documents the right way. Something is that simple. They didn't sign the document appropriately, and guess what? The will was invalid. And so they paid for their $80 will or $100 will online. They saved $2,000 from going to a lawyer or whatever they saved. Guess what? Half the estate went to two estranged daughters, and then the other half went to the wife, versus the entire estate going to the wife and cutting out the two estranged daughters, all to save $2,000 by doing it online. So the issue with doing it online is things like that. Again, these programs are great. They're filling the blanks, but at the end of the day, you're not working with a human being that's there to ask you questions and there to challenge you respectfully and there to get you to think about certain things that you may not consider. I'm going to say that the idea, I would much rather somebody use TurboTax for their taxes than LegalZoom for their legal documents. And I despise TurboTax too, frankly, but that's a whole other story. So I won't go any further than that. Why won't doctors sign it? I think that was related to the Pulse document when I was talking about it. I think I answered that. I mean, doctors won't sign it because in a lot of cases, they just don't think that their patients are thinking about it fully. They don't think that their patients are really understanding that, hey, listen, you're 65 and pretty healthy. What if you had a heart attack tomorrow? If you sign that Pulse and you have a heart attack and you have no pulse and you're not breathing, they're not going to resuscitate you. You probably want to be resuscitated. So there's good reason why the doctors, in most cases, there's very good reason why the doctors won't sign it. Now, in some cases, there's just doctors that don't want to sign it. And so I tell my clients, well, then go somewhere else. Not switch doctors, but maybe get another medical professional to meet with. Is the 5 wishes document still valid? It is, and I don't mind it, but do not sign this. First of all, I really don't like clients signing it. I'll be honest with you. I don't like people signing it as a replacement for a healthcare power of attorney, no matter what, because the 5 wishes purports to be legally binding in like 48 of the 50 states. And power of attorney documents are specific to every state. But hear me out. I like the 5 wishes because it goes into a lot of detail. Okay. And there's the power of attorney for healthcare. If anybody has one, you know that it goes into zero detail. It's great at naming somebody to make a decision for you. It's great at saying, you know, I value the quality of my life over the quantity, but that's about all it's good at. And I get that. All right. So here's what I tell clients. I'm like, listen, if you like the 5 wishes, great. I'm for it. Then do one of 2 things. Either take some of the language in the 5 wishes and type it up on your own and sort of make an addendum, and then we can staple that onto your healthcare power of attorney. Because at the end of the day, it's not like you hand the 5 wishes to the doctor and the doctor's like, oh, this is what Susan wanted, so I guess that's what we're going to do. It's not how it works, guys. The 5 wishes and the healthcare power of attorney, even if I check the box that says don't keep me alive unnecessarily, my power of attorney can do the opposite. My wife can keep me alive forever. I'm sure she will because she loves me tremendously, but they can do the opposite of what we say. So I tell my clients, listen, take the language from the 5 wishes you like, type it up, or attach it. Just take the 5 wishes and attach it to your power of attorney, but don't sign it. I don't want you signing the 5 wishes. Attach it. Have it have all your writing in it. Again, there's no difference whether you're signing it or not. The power of attorney that you're naming, you know, your spouse, your adult child, your good friend, your cousin, your niece, your nephew, why should it matter if you sign it or not, that they would follow it? I just don't want you signing it because I don't want ever getting into the wrong hands where somebody's like, oh, this revokes your healthcare power of attorney. That's my concern, that somebody takes that and it revokes your healthcare power of attorney. So I like the detail that it goes into. Please use the detail to your advantage. But I really just don't want it being signed. I don't want that to be the document that somebody is going to say takes over from your healthcare power of attorney. There's my short, not so short answer. Do wills have to be notarized in Illinois? This is terrible. Technically, I don't think they have to be, but we notarize all of our wills in our office. So I'm gonna say yes, even though I think the legal answer is actually no. And I'm saying yes because we notarize every single will, like I said. I think legally a will does not. I think a will just needs 2 witnesses. I'm just being honest. It's awful that I can't give you a direct answer on that. But we've been notarizing for so long that in my head we do. But I think if I'm being honest, I don't think it technically has to be. Let me see. I've got the statute up right now. No, you don't. Okay. Statute. Illinois statute does not have to be notarized, but we recommend that it does. Like I said, since I've been doing this for 12 years, we've notarized every single will. What takes precedence between healthcare POA and living will? Well, living will does not name a decision maker. A living will just makes a decision. The healthcare POA is gonna take precedent. Healthcare POA is gonna take precedent. Can my wife drive the car if it's not titled in both our names? It's not necessarily, that's not really up my alley. I'm gonna say yes. Yeah, I mean, I can drive anybody's car. I think that's more of an insurance question. I think that's just, you know, are you covered on her insurance? So, yeah. Thanks very much. What's the ballpark figure? I'll put my contact info in there. I really don't like to give fees out. I mean, my fees don't change. I don't like give different fees to different people, but I prefer, and I'm very upfront about my fees. I just don't like to throw my fees out into a big group, especially because I would rather give you a fee that makes more sense for just you, and I don't want to give it to everybody where it may not be appropriate for somebody else. So I will put my contact info in the chat box, and I think that was the last question, Sabina. That's it.
Thank you so much. And you put your contact info. I did share also, and Matt has his website here. I'll resend this to everybody too. And as Michelle mentioned, we do have a program evaluation that you will all get after the program. So we're really grateful for you today, and lots of questions and engaging conversation. So thank you so much for being here. Thank
Yeah.
you, Matt.